In Washington state, child support is outlined in what's called a child support order. The intent of the child support laws is to equitably apportion the obligation of providing for the child's needs between both parents, though it may not always seem like that's the outcome. Washington calculates child support using a fixed formula that's primarily based on the income of both parents. It's important that support for your child be correctly calculated, as it's difficult to change later. Inaccuracies, even in small amounts, can accumulate to total a lot of money over many years of payment. If a parent is not working or is believed to be working below their capabilities intentionally, their wages can be imputed. That means the court can assess an income value to a parent based on a number of factors beyond their actual paycheck. The courts can look at relevant information like current income, past income, median income reports, minimum wage in the area the parent lives, and other factors to impute the income of the party. The amount of child support that's to be paid may be adjusted based on the amount of time the child is spending with each parent. It's a complex system, and it's important to understand what counts as income and what deviations are allowed from the required formula. Keep in mind that the government takes child support enforcement very seriously. There are far-reaching consequences to evading child support enforceable by law. These include driver's and professional license suspensions, state and federal income tax offsets and garnishments, liens on or seizure of real or personal property owned by the debtor, freezing of bank accounts, and passport suspension or denial. Once an order of child support is issued by the court, it can only be changed by another court order. This is a complicated process, initiated by filing a petition to modify child support with the court and appearing at a hearing. A request for modification can be made at any time after the support order has been in place if there's been a substantial change in circumstances, such as significant changes in income, loss of employment, or change in custody of the child. As mentioned previously, these cannot be voluntary changes in employment. Modifications can be made without a substantial change in circumstances after 1 year if the order is causing severe economic hardship or the support needs to be extended while the child completes high school, or after 2 years for changes of income or changes in economic table or standards set out by Washington law. When starting the divorce process, temporary child support orders can be put in place to provide for the children until the divorce is finalized. The process for calculating temporary child support is the same as for permanent support, with the possible exception of having to provide child support for stepchildren on a temporary basis. Child support issues are complex and will be best addressed by speaking with an attorney who understands the laws and how the courts enforce them. For more information on the divorce process and family law issues, watch the other videos in our divorce course series.